I wanted to give a disclaimer about is that I'm making these videos really just for myself. If I can help someone do better on the test because you found the channel and you watch the videos, that's great. Papers filed in court. A, adoption. A.S., adoption surrender. B, commitment of guardianship and custody pursuant to the social services law. C, conciliation. D, delinquency. E, designated felony delinquency, including criminal court transfers. F, support. Guardianship is G. L, approval of foster care placement. M, consent to marry. N, neglect or child abuse. O, family offense. P, paternity. R, referred from Supreme Court except for delinquency. S, person needed supervision. U, uniform interstate family support law. V, custody of minors. W, material witness. Z, miscellaneous. Then it goes on to say that proceedings for extensions of placement and JD proceedings in permanency hearings shall bear the prefix and docket number of the original proceeding in which a placement was made. Permanency hearings for children free for adoption shall bear the prefix and docket number of the proceedings in where he was freed for adoption or surrender, or the termination of parental rights proceeding docket. Permanency reports submitted pursuant to 10-A shall not be considered new petitions. 205.7-A, electronic transmission of orders of protection. That just says that unless the petitioner states that they're going to make other arrangements, they're going to serve the other side, or they're going to deliver it personally to the law enforcement agency, the family court may transmit the order by fax or electronic means, and the proof of service must be submitted to the court, and the agency may not charge a fee for the service. Such transmission of the proof of service shall constitute the filing required by Section 160 of the Family Court Act. Okay, 205.7-B is the pilot program for the, electronically filed petitions. So the thing is, they can have this done by audiovisual means in order to accommodate litigants whom attendance at court would constitute undue hardship, a risk of harm, and they can get emergency relief. And the chief administrator shall strive for programs that are regionally diverse and shall take into consideration the availability of public transportation, population density, and the availability of suitable program facilities. So, you can't have the place in the middle of nowhere. It won't help anybody. In planning pilot programs, chief administrator will consult with one or more programs providing assistance to victims of domestic violence, the Office for the Prevention of Domestic Violence, and the lawyers who represent the petitioners in family offense cases. Plan shall include, but not be limited to, identification of family justice centers or other appropriate places that have access to the electronic equipment, assessment of family court and other court system resources, delineation of procedures for filing a petition, swearing in the petitioners and witnesses, preparing transcripts of testimony and a record of evidence deduced, and prompt transmission of the order to the petitioner. B, a timetable for, that's supposed to be 5. 5, a timetable for implementation of public notice of pilot programs. 6, a description of data to be collected to evaluate and improve the program. Procedures of each pilot program shall provide that the appearance and testimony will be voluntary, and the consent of the participating petitioner shall be stated on the record at the commencement of the proceeding. They must file a petition in advance and may do so by electronic means with the assistance of trained advocates. The petition shall set forth the circumstances in which a courthouse appearance would constitute undue hardship or create a risk of harm to petitioner. Documentary evidence referred to by a party or witness of the court may be transmitted, submitted, and introduced by electronic means. In granting or denying relief sought in petition, court shall state the names of the participants, whether or not it's granting or denying an appearance by electronic means, and the basis for such determination. Parties shall not be compelled to file a petition or document by electronic means or testify by electronic appearance. Okay. Electronic appearance shall be recorded and preserved for transcription. Pilot programs shall not affect or change any existing laws governing service or process, including personal service or the sealing confidentiality of family court records or access to family court records. The chief administrator shall maintain a current and publicly available listing of sites where petitioners may make applications and appearances under pilot programs pursuant to this section. Same as 205.8, same as civil 205.9. Miscellaneous proceedings, consent to marry, interstate compacts on juveniles and material witness shall be commenced by filing a petition and shall require the entry of a written order. 205.10, 10 days for the lawyer's notice of appearance after appointment or retainer, whichever sooner. Notice shall contain lawyer's name, office address, telephone number, and the client's name. 205.11, service and filing of motions in the family court rules. A, motion shall be made returnable at the hour judge directs. Same as CPLR 2214, they have to serve their papers on the lawyers and any pro se party. Affidavit, statement of relevant facts, briefs or a statement of relevant law. Unless otherwise directed by court, the answering and replies should be filed no later than the time of argument or submission of motion. The assigned judge may determine that motions be orally argued and may direct the papers to be filed with the court prior to the time of argument. Unless oral arguments directed or requested by a party and permitted by the court, motion papers shall be received and the motion is deemed submitted. A party requesting oral argument shall set forth such request in his notice of motion or on the first page of the answering papers as the case may be. Party requesting oral argument on an OSC shall do so as soon as practicable before the time the motion is to be heard. Hearings on motion shall be held when required by statute or ordered by the assigned judge in judge's discretion. Temporary custody or visitation, once a hearing or trial commences, shall proceed to conclusion within 90 days. 205.15. Proposed orders have to be submitted to the court within 30 days after the signing and filing of the decision directing that the order be settled or submitted. In child protective, pursuant to 10 and 10-A, they have to be submitted for signature immediately, then later than 14 days of the earlier of the court's oral announcement of its decision or signing and filing of its decision, unless otherwise directed. They have to be submitted immediately, but in no event later than the next court date following the removal of the child. Orders and termination of parental rights shall not be more than 14 days after the earlier oral announcement or signing and filing of its decision. So the 14 days is 10-A, Article 6 in termination of parental rights, and 384B of SSL. The next court date one is for 10/22, and then everything else is 30 days, okay? But if they ask the question, like, when does the lawyer have to settle the order? The answer would be immediately, but in no event later than as explained. 205.16, motion for judicial determination that reasonable efforts are not required for child and foster care. A motion for such determination shall be filed in writing on notice to the parties, including the child's lawyer, on a form officially promulgated by the fucking chief administrator and set forth in Chapter 4 of Subtitle D of this title and shall contain all information required therein. 205.17, which I'm not going to get to right now. This little rule, 205.17, there was a bunch of time rules in it. The initial permanency hearing had to be held within 8 months. Then the next permanency hearing, after the initial one was 8 months, the next one is 6 months. And then there was the reports thing was 14 days. So in that little section, there was 1, 2, 3, 4, 5 papers to be submitted. 1, a sworn permanency report that's on the promulgated form. 2, additional reports and documents as directed by court, which includes but not limited to periodic school cards, photographs of child, clinical evaluations of prior orders and related proceedings. 3, a copy of the report submitted to family court must be sworn and must be accompanied by a list of all persons and addresses to whom the report and/or notice of the hearing were sent. Except as otherwise directed, the list containing the addresses shall be confidential and shall not be a part of the court record that may be subject to disclosure 205.5 of this title. Copies of the permanency hearing report required to be sent to the parties and the lawyers, including child's attorney, not less than 14 days prior to scheduled date certain, need not be sworn, so long as the verification accompanying the family court sworn copy attests to the fact the copies were transmitted as identical in all other respects to the court's sworn copy. Okay, E. In any permanency hearing under Article 10-A, child gets a lawyer, and the family court shall consider the child's position regarding the permanency plan. The initial permanency hearing had to be held within 8 months. Then the next permanency hearing, after the initial one was 8 months, the next one is 6 months. And then there was the reports thing was 14 days. So in that little section, there was 1, 2, 3, 4, 5 times scheduling for dates certain. Deadlines for submitting permanency reports. 1. The first order remanding a child into foster care or into direct placement in a proceeding pursuant to Article 10 or approving a voluntary placement instrument pursuant to Section 358-A SSL must contain a date certain for the initial permanency hearing pursuant to Article 10-A, which must not be later than 8 months from the date of removal of the child from his home. If child had a sibling or half-sibling whose permanency hearing is scheduled before the court, date certain shall be the same as the date certain for the siblings, unless the sibling was removed on a JD or PINS petition, or unless either sibling has been freed for adoption. 2. A permanency hearing with respect to a child who has been freed for adoption shall be scheduled for a date certain not more than 30 days after the earlier of the judge's oral announcement of its decision or the signing and filing of its decision freeing the child for adoption. 3. In any case where a court made a determination that reasonable efforts are not required, permanency hearing must be scheduled for a date certain within 30 days of the determination, and the originally scheduled date shall not be canceled. In such a case, the permanency hearing report shall be transmitted to the parties and lawyers, including child's attorney, on an expedited basis as directed by the court. 4. Each permanency hearing order must contain a date certain for the next permanency hearing, which shall not be more than 6 months from the completion of the other permanency hearing, except as provided in paragraph 3. Except with respect to a child freed for adoption, if the sibling has been or half-sibling has been removed from the home, whose permanency hearing is scheduled before this court, the date certain shall be the same as the date certain for their hearing, unless the sibling or half-sibling was removed on a JD or PINS petition, or unless each sibling has been free for adoption. 5. If the child has been adopted or the subject of a final order of discharge or custody or guardianship by a scheduled date certain, the permanency hearing shall be canceled, and the petitioner shall promptly so notify the court, all parties and their lawyers, as well as individuals required to be notified of the hearing pursuant to FCA 1089. C. Required notice and transmittal of permanency reports. Except in cases involving children free for adoption, in addition to sending the permanency hearing report and the accompanying papers to the respondent's parents' last known addresses and their lawyers not less than 14 days in advance of the hearing date, the petitioner shall make reasonable efforts to provide actual notice to the respondent parents through any available means, including but not limited to casework, service, and visiting contacts. Additionally, not less than 14 days in advance of the hearing date, petitioner shall send a notice of the permanency hearing and the report and accompanying documents to the non-respondent parents and the foster parent or parent caring for the child, each of whom shall be a party, and to a child's lawyer. Petitioners shall also send the notice and report to a pre-adopted parent or relative providing care for the child, and shall send the notice, but not the report, to former foster parents who care for the child in excess of 1 year, unless the court dispense with the notice. The court shall give such persons an opportunity to be heard, but they shall not be considered parties, and their failures to appear shall not constitute cause to delay the hearing. As provided in sub D, petitioners shall submit on or before return date documentation of the notice or notices given to the respondent and non-respondent parents, their lawyers, child's lawyer, and any present or former foster parent, pre-adopted parent, or relative.